Parole is the system where a prisoner is released from prison on licence in certain circumstances. Determinate sentence prisoners, i.e. those that have been given a set number of months or years, are automatically released at the halfway stage of their sentence. The Parole Board aren't involved in that process. Where the Parole Board do become involved in determinate sentence prisoners is where a prisoner has been recalled to prison for breaching their licence. This recall can be either for a fixed period or for the remainder of the licence period. A recall can happen in a number of reasons, and it is a popular misconception that you can only be recalled for committing another offence. This isn't true. You can be recalled on the basis of not informing your community offender manager about a developing relationship, a job, not attending scheduled appointments, or being of good behaviour. The conditions of a licence are set out in the licence and all carry the same weight of recall. For those serving a life sentence and being eligible for consideration, an extended determinate sentence or an IPP sentence, satisfying a parole board that you should be released is the only method to achieve release. There are two types of parole hearings, a paper hearing and an oral hearing. A paper hearing occurs at the outset in every case. This is where an accredited member case assessment, or MCA, determines whether the case can be concluded on the papers or whether further steps are necessary to reach a conclusion. An oral hearing is ordered in cases where the MCA has been unable to reach a decision or where fairness dictates that one should be ordered. An oral hearing allows for the constructive panel to assess the prisoner's risk of reoffending and the circumstances surrounding recall, if applicable, and the offence to which the prisoner has been sentenced. This is called the indexed offence. A constructive panel is made up from members of the Parole Board and can consist of 1 to 3 people. The panel include retired judges, specialist members such as psychologists, and trained members of the public. The panel's judicial function is set in accordance with assessing a prisoner's risk of serious harm. This is called the statutory test and is contained within the Criminal Justice Act of 2003 as amended. The Parole Board must not give a direction for release unless the board is satisfied that it is no longer necessary for the protection of the public that the person should be confined. We at Duncan Lewis Solicitors have a high success rate in assisting prisoners obtain parole. We regularly appear at oral hearings and individually are members of the Association of Prison Lawyers. We pride ourselves in being up to date with the latest case law and policy decisions regarding parole. Please visit our website or call us directly on 0333 772 0409.